In an exclusive interview with the Draft Constitution Consultant for TANGO, lawyer Kausumane deliberated on some of the amendments which have been effected on the 2024 Draft Constitution.
The debate is all over the place, from the National Assembly to the public out there. It's important that it's a challenging point at this point. It's like Gambia is at a crossroad again. History is repeating itself. We don't expect to be at this crucial stage as of this time and date. So, but unfortunately, we have found ourselves in a situation we have no choice but to deal with it. Yes, and that is a constitutional amendment process. Constitutional amendment or process is a process. It's not an event. It takes stages from one stage to another. And we have seen what really happened from the 2020 draft constitution to that of the 2024 draft constitution. But there were substantial amendments. There were some omissions, there were some additions here and there. And I think everybody is talking about it, and everybody knows what has been removed and what has been added. People are talking about Chapter 5, which has to do with leadership and integrity. That's one aspect. So if you look at local government decentralization also has been removed from the 2024 document. Overall, comparatively, the two documents, what I've seen is like separation of powers has been compromised, where there is judicial independence or legislative oversight. All those things have been compromised. If there is anything that the National Assembly has to do in confirming appointments from the presidency, or anything the judicial have to do in exercising their judicial powers of judicial review, has been curtailed seriously. So in short, separation of powers has been compromised, and which is one of the principles of constitutional governance.
Lawyer Mani also questioned the government's mandate to amend and publish a new draft constitution as it did in August 2024.
If we were talking about the content now, we are trying to justify what has happened. And unfortunately, in our own constitutional setting or arrangement, we don't have what we call constituent assembly. In some jurisdictions, they call it constituent assembly or constitutional commission. In the event a constitution has been drafted, taken through the stages, and there are issues that people need to highlight or whatever, do something about them, you send the book to the whole document to that constituent assembly or constitutional commission. It's their responsibility. They have the mandate to remove, to add, to modify, and to do some adjustments on the document. Unfortunately, we don't have that in our current constitutional arrangement. So I don't know where the power or the fiat, the legitimacy come from, the legality of assigning somebody to go and do, add, make addition, make omission here and there from a national document. I don't see any legality, and I don't know where the power comes from. My understanding is that whoever is assigned to do whatever, that has to come from the National Assembly. That's the National Assembly's mandate, and is their inherent jurisdiction to look, we are assigning X, Y, Z, or a particular institution or a particular body to look at the document. Unfortunately, we don't have any constituent assembly in our own arrangement. So therefore, the mandate has to come from National Assembly to assign whoever is going to be responsible to do whatever with the document. That's my position on that.
Edward Francis Dahlia, reporting for Askanwi.